Hi, good afternoon, everyone, and welcome to this webinar on the latest presidential proclamation of June 22nd, 2020. My name is Dia Matthews, and I'm an immigration attorney with the New Jersey offices of Chugh, LLP. We know that the June 22nd proclamation has led to a number of questions and consternation from employers and visa beneficiaries. To discuss the ramifications of this proclamation and its consequences for you, whether as an employer or as an employee in a visa status, we have today a stellar panel comprising immigration practitioners from the various offices of our firm. A general disclaimer that this presentation is for informational purposes, and for any legal advice pertaining to your specific situation, you should contact an immigration attorney. So I'll briefly introduce the panel here. From our West Coast office in Santa Clara, we have Navdeep Miambar, Gurshan Chata, and Brittany Simmons. From the New York office, we have Hafizuddin. From our Reston, Virginia office, we have Jagan Tamirisa. And last, but certainly not the least, from the Edison, New Jersey office, we have Min Kim. So let's get right into it. I'll request my colleague Hafiz to walk us through the salient points of this proclamation. Go ahead, Hafiz.
Thank you, Dia. Today, our teams will discuss the latest presidential proclamation, most recently issued on June 22nd, 2020. This proclamation follows in the footsteps and in a similar fashion as the previous April 22nd proclamation issued by the Trump administration. The stated objective and the title of the proclamation being suspending entry of aliens who present a risk to the labor market following the coronavirus outbreak. The objective being to minimize, as per the administration's position, to minimize the impact of the coronavirus on employment conditions through immigration restrictions. As will be further discussed by my colleagues, where the prior proclamation directives involved mostly certain immigrant visa restrictions for a period of 60 days, this new directive extends the 60-day period to the end of the year to December 31st, 2020, with the indication that it may be further continued as necessary. The proclamation also adds additional restrictions involving non-immigrant workers, as my colleagues will discuss later, including the H-1B, the H-2B, the ELD, J-1 non-immigrant classifications. The June 22nd proclamation suspends foreign nationals from entering the U.S. if they were already outside of the U.S. and did not hold a U.S. visa or travel document. Thus, though they only impact those individuals who are outside the U.S. and not already holding a visa, in view of the H-1B cap season that's upon us right now and the use of the L1 visa by a great number of foreign nationals, the impact will nonetheless be very substantial. The proclamation picks up on the prior order's recommendation regarding ongoing and continuing review of immigration matters to determine additional steps necessary to address the COVID pandemic and employment concerns arising thereto. And of notice here is that this proclamation also hints at potential additional upcoming restrictions regarding immigrant matters, possibly the EB2, the EB3 immigrant categories. Hence, as in the prior order, the Trump administration appears to be looking at instituting sequel orders in the coming months involving additional immigrant visas, including possibly the PERM and so forth. Through this program, my colleagues and I will endeavor to answer and clarify details regarding the most common questions we've been encountering regarding the proclamation, including who is impacted, exclusions from the proclamation, the duration of the orders underlying the proclamation, the impact of future visa filings, and potential strategic next step considerations for employers. We'll then take questions to answer audience questions. Dia, to you.
Right. Thanks, Hafiz. Very helpful overview. Next, I'll ask Min to talk to us about how this proclamation, how the June proclamation differs from the prior presidential proclamation of April 22nd.
Thanks, Dia. So the previous presidential proclamation that was signed by President Trump and issued on April 22nd, in effect, it essentially suspended the entry of certain quote unquote immigrants for 60 days. Now here, I do want to take some time to be precise in defining the word immigrant. When it comes to U.S. immigration law, immigrant has a pretty narrow definition. I suppose for our purposes here today, we can say that immigrants are defined as applicants for U.S. permanent residence. So therefore, this proclamation a couple of months back was not targeted for individuals who are seeking to enter the U.S. on a temporary non-immigrant visa, such as an H-1B visa, L-1, TN, any kind of temporary visa status, for employment or even family-based purposes. If that intention was to visit the U.S. on a temporary basis, this proclamation did not bear any kind of consequence. Another term that we have to be precise here is that the proclamation was intended to target individuals who are applying for a visa. Now, the word visa also has a very specific.
Sorry, Min, let me just ask the other attendees to mute their lines when they're not speaking. Sorry, yeah, go ahead, Min. Sorry.
Thank you, Dia. The word visa is important to define because when it comes to immigration law, the word visa, it essentially means a travel document. The visa is what's granted to a foreign national who applies with the U.S. consular post abroad to secure the approved travel document to seek entry into the U.S. and therefore seek admission status in the U.S. Once they pass inspection through CBP. Why is this important? It's important because this April 22nd, presidential proclamation, the suspending immigrant visas was intended to only suspend the travel documents issued by the consulate for individuals who are seeking to come into the U.S. on a permanent basis. So therefore, as folks might know already here on the webinar, the consulates were already closed as a result of COVID-19. So they weren't really accepting visa applications in general. So the practical real life impact of the proclamation a couple of months back was very negligible because it did not impact the individuals who already were granted visa status in the US because they were already in the US. So this presidential proclamation did not impact those people already here. It's important to know that there were certain exceptions carved out, individuals who are already U.S. permanent residents, folks who already have an approved U.S. travel document such as an advance parole, spouses and minor children of U.S. citizens, as well as individuals applying through the EB-5 immigrant visa program. They were specifically carved out as exceptions. So the focus and the objective of the proclamation a couple of months ago by the president was very narrow. Just once again to underscore the relevant point, the proclamation did not impact individuals in the U.S. Even if those individuals were applying for a green card, perhaps they were sponsored by their employer or maybe a qualifying family member through an approved I-140 petition or an I-130 immigrant petition for alien relative, those individuals were accepted as well because they were physically in the U.S. It was only meant for consular operations. Just to kind of wrap up the key differences between the April 22nd and the June 22nd proclamation. One key difference is, obviously the June 22nd extended the April 22nd proclamation until December 31st, as my colleague Hafiz just mentioned. I suppose essentially the June proclamation that was just issued absorbed the April 22nd proclamation and extended it with possible renewals thereafter. And as Hafiz mentioned earlier, now the ban of foreign nationals was extended to temporary visa categories. So individuals who are looking to file an H-1B visa at the consulate or an L-1 or perhaps an H-2B, let's say, and some limited J-1 visa categories, those people are now suspended entry into the US as well. Back to you, Dia.
Thanks, Min. Thanks. I think it was especially helpful for you to clarify the difference between, the petition pending status in the US and those applying for a visa, and just also clarifying the exact, the actual meaning of the term visa. So very helpful. Okay, next I'm going to ask Navdeep to talk to us specifically about what sort of an impact this would have on visa applications at the US consulates abroad.
Thank you, Dia. So let's see which visas are impacted by the current proclamation. The visa applications which file for H-1B, specialty occupation workers, and their dependents, which would be H-4s, or L1s. L1s could be L1A intra-company transferee as a manager, or L1B as a specialized knowledge, or the dependents which get on L2. Along with that, also J1 exchange program workers or the dependents on J2. And also lastly, H2B seasonal non-agriculture workers. So if you are applying for a visa under any of these classifications, H1Bs, Ls, J1s, and H2B, you cannot go apply till the end of this year. If you are any other classification, that's fine. Also, once again, to confirm that visa is the travel document you file for the consulate, this doesn't mean that you cannot do H1B or L1 filing in the US with USCIS. So now let's see that who is impacted by this proclamation. So along with those visa classifications, you have to meet these requirements as well. So you were outside the United States on June 24th, 2020. And do not already hold a non-immigrant visa valid on the effective date of the proclamation. So if you were outside the US and also do not hold a non-immigrant US visa valid on this date, you cannot go get a visa till the end of this year. And do not hold any official travel document. So if one is like, if you apply for a visa, or sometimes people are traveling because they have advanced parole document. If you have a 485 pending with the USCIS, you have an advanced parole document. So you could travel and come back to the US with your advanced parole. You do not need a visa. So you basically do not hold any of these official travel documents like a transportation letter, boarding foil, or advanced parole document. So these are the ones who are basically impacted by the current proclamation. Thank you, Dia. Back to you.
Thank you. So Navdeep, it sounds pretty bad. It sounds like quite a few visa categories are affected, but I also understand there are some exceptions to these restrictions, right? So Brittany, if you could talk to us about the exemptions to that.
Yeah, thank you, Dia. So there are several exemptions from this proclamation, and they include Canadian citizens, legal permanent residents, so your green card holders, spouses or children of U.S. citizens, temporary workers that help with the U.S. food supply chain, and then also those that are seeking to enter for a national interest. Now, this national interest, it can be U.S. defense, national security, law enforcement, or those that are providing medical care or research for the COVID-19 pandemic. Just to note, however, is that we still are unsure as to how you go about to apply for these exemptions, since at this time all we know is that you have to have a determination from the Secretary of State or the Secretary of Homeland Security. Also, these exemptions are very narrow and need to be time tested. Further, those seeking humanitarian relief and protection under U.S. law are exempt from this proclamation. Back to you, Dia.
Thank you. Thanks, Brittany. Okay, so how long should we expect to deal with all of these restrictions? Gulshan, you want to tell us about that?
Yes, thank you, Dia. So currently, this proclamation is set to expire on December 31st, 2020, but language stated that it may be continued as necessary. So a lot of this will depend on the 2020 presidential elections, on what party comes into power and how they choose to extend this proclamation. Also, if there's any lawsuit that comes out of this, which we expect it will, and what would happen with that lawsuit will depend on how long this is extended. Also, the Secretary of Homeland Security will review and reevaluate policy every 60 days and within the first 30 days of June 24th, 2020. Also, the Secretary of Labor and Homeland Security will evaluate H-1B and green card EB2 and EB3 programs to ensure that they do not disadvantage any U.S. workers, which was the basis of the whole proclamation. So to sum it up, currently it's set to expire on December 31st, 2020, but we are not sure how long or if this will be extended. Back to you, Dia.
Thank you. So Jagan, can you tell us now what should employers and employees plan for the near future with all of this going on? What kind of planning should they do?
Thank you, Dia. So the basic question that leaves is with 2 consecutive executive orders, what's left and what programs have been closed. So after reviewing the executive order, what we found is that nothing much has changed with respect to people who are physically present in the US. What I mean is, for example, the TN visa for Mexican and Canadian professionals has not been affected. You can still bring them in. F1 student visas, E-investor visas, O1s, E3 Australia, and religious worker programs are also not affected. However, the suspension of consular service may make it a challenge for them to apply for visa stamps at the consulates. Canadian citizens, as has been re-emphasized before, since they don't need visas, they can come here on HJ and L status at this point. With respect to H-1B petitions, it does not affect any employer's ability to file extensions, change of status, transfers, amendments, or any of those kinds. Whatever has been happening before continues to be followed right now. It does not prevent an employer from filing H-1 petitions for those who have just got selected under the H-1B cap. If an employee cannot change status in the US, the employer can still file the H-1 petition with consular process, but that person may be prevented from entering the US because they may not be issued a visa. H-1B cap cases can be filed through June 30th, tomorrow being the last day. And if your H-1B cap has been filed as a consular process, you still have time after you get your receipt to request USCIS to convert it to change of status instead of consular process. We do not expect the entry ban to affect adjudication of any of these H-1B cap cases, but obviously everybody knows that USCIS may be furloughing a lot of employees coming months, so we just have to wait and see how that's going to affect the processing. On a plain reading of the executive order, it appears that the entry ban does not apply to H-1B1 Singapore and Chile free trade visas, but this is a mere presumption at this point. We have to wait for further clarification from the government on this. Coming back to L1 petitions, nothing has changed for them. If there's a employee in the US on L1, the employers can continue to file amendments, extensions for them on a timely basis. The only L1 visas that may actually be affected is the blanket ones. So individuals who prefer to go through the L1 blanket process may be prevented from entering the US if they have not been issued visas. So company planning to transfer key employees may want to file individual petitions in the US between now and December, with the assumption that as soon as the consulate opens, the only thing you are waiting for is a visa. The assumption, the advantage with that is the petitions that are approved by USCIS are usually routinely not questioned at the consulate. But the case is opposite when it's a blanket, where consulars actually adjudicate the blanket visas. And if things change from now to December, which is expected to, the adjudication standards may become more difficult. We have seen a lot of people applying for F1 change of status because probably they got laid off due to COVID-19 and all, and they may be in grace period. F1 visas has not been affected. You can still apply for change of status to F1. The entry ban does not affect students' ability to pursue their programs, nor work on their OPT or STEM OPT or travel internationally. Coming to green cards, PERM and I-140s, nothing has changed. You can continue to file I-140s and PERMs as usual. Those who are eligible to proceed beyond I-140 should consider filing 485 rather than consular process. If you already have an I-140 approved as a consular process, you can still apply for 485 if you're physically present in the US. But note that you can't pursue both consular process and 485 at the same time. Executive order does apply to diversity visa applicants, green cards with certain exceptions. EB-5 program has not been affected. Spouses and children of US citizens are not affected. So you can go for both consular process and I-485. Parents, brothers and sisters of US citizens are not exempted. So if they are physically present in the US, you should go for 485 rather than consular process. Likewise, spouse and children of green card holders are not exempted. They should also consider going for 485 if they are present in the US. So looking ahead, obviously what my colleagues have been saying, valid visas issuance may be affected, but the proclamation does not say anybody who has been issued visas will be revoked. So once the visa is issued, they may not be revoked, so they continue to be valid. Back to you, Dia.
Thank you. Thanks, Jagan. That was a lot of information, and hopefully our attendees are well served by all of this. We have a few questions now, so we can go over the questions in the order that they come in. So Navdeep, if I may ask you to take this one, and the question is, I am on an L1A visa and I have filed for the green card last December. So for by green card, I don't know if they mean I-140 and the 485 together, but yeah, so in L1A status and green card application pending since last December, how does the proclamation affect me?
Okay, so yeah, so if I understand, if you're already on L1A in the US, as you said, L1A visa, if you're already in the US, does not impact you. You know, as we mentioned earlier, it impacts who are not in the US at the date of June 24th. So you're already here, and if you already have a visa, you can travel using your visa. Though we are advising to avoid traveling these days because every day, you know, new rules are coming and it can impact on the future. But with you already have L1A approval, you are L1 approval here in the US, you are fine. You're not impacted. And also along with a green card, if it's at I-140 stage or a 485 is filed and pending, you are not impacted by the latest proclamation. The process will continue as it is. So no impact on L1 or a green card in the US.
Thank you. Min, perhaps you can take this next question. And the question is, with Trump's recent suspension of new H-1B visas through 2020 and the green card ban extended through December 31st, what does it mean for employers? So pretty broad-based, but yeah, whatever you can tell us in response.
Right. So it is a pretty broad question, and you know, hopefully the topics covered in today's slide and presentation answered a lot of those questions. I suppose, you know, generally speaking, it's too early to say definitively what the exact impact might be. I do think that it's clear that, you know, the objective for the administration is that they want to target H-1B cap employees, individuals who do not have an H-1B visa foil approved yet, you know, by the consulate, and those individuals are presently outside U.S. territory. So U.S. employers are looking to bring those individuals here to the U.S. It's rather clear, and I don't think there really is any argument otherwise, that this proclamation affects that population directly. So it appears those individuals might have to wait, you know, until earliest 2021 to perhaps visit the U.S. and be admitted as a temporary worker to engage in H-1B employment. And I suppose all this is under the caveat there is no intervening lawsuit. I believe one of my colleagues might have mentioned that you know, there are certain, you know, rumblings that we're hearing that, you know, a federal court case might be filed, and as part of the court case, you know, stakeholders are looking to perhaps put a temporary hold on the impact of this proclamation. And if that's the case, then I suppose everyone here in the webinar can expect that everything's going to go back to the status quo. How the federal court works is that, you know, if they do decide and agree with those stakeholders saying that before we put this proclamation into effect, or we allow, you know, the president to put this into effect, we're going to bring everything back to the status quo, and then we're going to, you know, look to litigate this. So, I suppose because of these different variables, it's hard to say what tomorrow has in store because, who knows if a lawsuit's going to be filed, who knows how broad or how narrow this proclamation is going to be read. But I suppose, just as a parting point, U.S. employers can expect that this is just the first step. As part of the proclamation, and one of my colleagues might have referenced this earlier, it does invite leadership at the Labor Department and Homeland Security to promulgate regulations. So, what that means is it's just a fancy word of saying, the president knows that his hands are tied when it comes to limiting immigration here in the U.S. A lot of the things that he can prevent are individuals from overseas coming to the U.S. in the visa category. For individuals here in the U.S. who are lawfully admitted in the first place, I suppose in large part he can't touch those people unless he wants to be faced with a lawsuit. So the long-term solution, or quote-unquote solution, that the president has in mind is that if he really wants to undo a lot of U.S. lawful immigration sponsored by U.S. employers, he has to have his departments, Homeland Security, Labor Department, officially go through rulemaking and enter new federal rules that prevent immigration in the U.S. from happening. The proclamation does invite the leadership at those departments to engage in formal rulemaking. So we'll see. I suppose it's still early. We don't know what those department heads have in mind. They can impact the PERM labor certification program for sponsored EB2, EB3 individuals. I'm sure they have the H-1B visa program in mind. They might attack it both from an LCA standpoint with the LCA filing with the Department of Labor, as well as the overall definition of what an H-1B worker looks like, at the Homeland Security level. So I suppose, just generally speaking, there really is a lot of indecision and a lot of a gray area as we just continue on.
Right. Thanks, Ben. Okay. I'm going to go over some of the other questions we just received. So one was, has the extension of H4 and EAD applications in the US been affected? And I think generally the answer to that would be no, right? I don't see any slowdown in H4 or the H4 EAD adjudications. Next question, we have H4s and L2s are wanting to try and get to the US on a B2 and then change of status after they enter. Is this possible? Okay, this is a good question. So I guess what the attendee is asking is, can you get into the US on a B2 and then do a change of status to, some other visa category like an H or an L after that? Anybody want to take this? Hafiz?
Yeah, hi, yeah. So good question. So generally speaking, when someone enters on a B1, B2, the understanding is that they're coming in for a temporary period with the intention of returning back, leaving the US upon the completion of that temporary purpose. If they have some other purpose or some other intention, there's a potential misrepresentation that's being made there, and that obviously would be a problem. Individuals are allowed to come in on a B1, B2, and if there is a real genuine subsequent change in conditions which makes them do something which wasn't originally intended, that is permissible. So, but if they are coming in solely for that purpose, that would be something that's not permissible, and that could amount to potential fraud, misrepresentation. Yeah, so we wouldn't recommend that.
Right. And along the same lines, different visa category, but I also feel with the F1 change of status to F1, because a lot of employees have been asking about whether it's possible to do a change of status to F1 because their H1 visa time is running out, or L1 is running out, and things like that. And generally, I think our advice is that you have to be very careful when you do a change of status to F1, because USCIS tends to be skeptical of any visa, any F1 application that looks like it's been filed just because you don't have some other status to apply for, right? So if it is not really for study purposes, if you don't intend to go to school and attend classes and you're just using this to tide over or circumvent some visa issue, they are likely to deny the F1 visa, F1 petition, sorry, the F1 application. All right, next, and this I think is $1 million question. So the question is, if a US-based employee has an approved H-1B or L-1 approval notice, can he exit and get a visa stamping done to come back to the US? I'm going to ask Min to address this. Min, do you want me to repeat the question? So
no, I see it right here. I see it here in the chat box. So this is the question that you're referring to. So once again, the question, if a US-based employee who has an approved approval notice, can he exit and get stamping done and enter back to the US? So I mean, I suppose, what comes to mind immediately is two scenarios. Does this US-based employee, was he or she issued a previous approved H-1B L-1 visa by the consulate that has since expired? Or has this foreign national in the US never went for visa stamping with the consulate? And the next time that he or she exits the US, that'll be the first time they make a visa application with with the US consulate in that particular visa category. I think for the second one, it's a little bit more clear. That person, if the proclamation were to remain in effect, there's no intervening litigation, a temporary restraining order, let's say, issued by the federal court to stop the continued impact of the proclamation. If that person departs the US and they're applying for their first H-1B visa, their first L-1 visa, then they might be challenged to return to the US. And I think reasonably speaking, if that's the case, they would have to wait until 2021. The first scenario is a little bit more tricky. There are two schools of thought, and I suppose, just conservatively speaking, if there's a way for that foreign national to be in the US and not exit and not have to, apply for their second or third visa foil with the consulate, that's what we would generally recommend. But the wording of the proclamation is drafted in a sense that if they have a visa that has expired in their passport, a narrower reading of the proclamation suggests that they can apply for a new visa stamp and then come back to the US because they had an existing visa already in his or her passport. Now, once again, I highly stress the word interpretation. This is just an interpretation. We don't know how Homeland Security, how CBP at the border is going to interpret this. It might very well be that narrow interpretation is not adopted, and it's going to be a more broad reading of excluding H-1B visa applicants. Just because an H-1B visa beneficiary 5 years ago had a H-1B visa approved by the consulate and has since expired, but they're going to go for quote unquote restamping. Well, that person might be excluded altogether. So I suppose our position as a firm has been that until there is more clarity from Homeland Security on how that provision is going to be read and interpreted by the different layers within the federal government, it might be best to just remain in the U.S. and not exit, even if it might be the second or third time someone's going to go for H-1B visa stamping.
Right. Right, agreed. I mean, I don't think there's any clear guidance from the government on this particular issue. I know people have been asking this, but at this time, unfortunately, I guess we just have to work with the text of the proclamation. All right. Okay, the next question, and this is an interesting question. I think this is also, there's something to think about. So the situation is the employee, the principal applicant, the H-1B holder, let's say, has gone overseas for a visa interview and is stuck there because of the proclamation. His dependents are currently in the US with valid status, and I-94 until 2022. Is the status of the dependents impacted because the principal visa holder is not in the US and is stuck overseas? Anybody have any thoughts on this? So this is a little specific, and the question is it okay for the dependents to stay on in the US while the principal visa holder is overseas? And we've had this, we see this frequently in immigration situations where the person goes overseas on a business trip or a vacation, and the family, the dependents, the spouse and the children are in the US. And generally there is no issue with this. They do have valid I-94. Right. So as long as they have a valid I-94, there is no unlawful presence. So I think for purposes of the webinar, let's leave it at that. And if you need any more specific advice, then feel free to reach out to us. By the way, at the end, yeah, so I think the slide is already up. There is an email address that's published there, info@chugh.com. So if you want to get in touch with us after the webinar, feel free to email us there. All right. The other question we had is, are E2 visas affected by this proclamation? E2 visas. Navdeep, can I request you to answer this?
Thanks, Dia. No, E2 visas are not impacted. Basically, as we said, this proclamation basically covers H1Bs, H4s, L1s, L2, their dependents, J1, J2s, and H2B seasonal workers.
Great, thank you. What about EB5s? I think people are asking about EB5 visas too. Jagan or Navdeep, if you could speak about EB5s. I believe there's a specific exemption for EB5s, right?
Yes, Dia, this is Jagan. There is a specific exemption for EB5 in the April 2020 proclamation that was given. So anyone who is a beneficiary of an EB5 application, they are okay to go ahead either with 485 or consular process.
Great, thank you. Okay, and TN visas. Anybody want to talk about TN visas? Are they affected by this?
I can take this, Dia. So yeah, again, TN visas are not impacted by this because they are one of the visa classification which is not covered. If you have a TN visa, you are fine to travel. Or if you do not have, you want to travel, yes, it's okay. It's not covered.
Right, thank you. Another question, we have employees in H1B, L1, we have employees in H1B and L1 visas and they have applied for their permanent residence. Are you seeing a slowdown in any of the processes? Hafiz, do you want to take this question? Do you see any slowdown in the adjudication? I guess the question is there a slowdown in the adjudication of H1Bs or L1s or I-140 petitions? Hafiz, are you unmuted? Okay, I don't hear.
Take this.
Yeah.
I can take
yes,
this.
Yes, go ahead, Navdeep.
So yeah, I mean, see again, I mean, this is not related to this latest proclamation, but since we do handle such H1 and L1s with the US filings and 485s, permanent residence. So any of the process, it's not really impacted by this one. There was slow processing times because of the COVID, offices were closed. We did notice there was delay and longer processing times. But otherwise, if you have employees, any H1 pending, L1 pending, and you have the option to convert to premium as well if you notice there is a delay. So that should not be a problem. But otherwise, the green card processes are going on as well. If it's a perm stage or it's I-140 stage, it's on, and for the 485 you have to wait for the date to be current, but otherwise if it's already pending, it's not being impacted.
Right, and then if this is Min, if I can just kind of piggyback off of that, I do tend to agree that it appears the current processing times for visa petitions filed with USCIS, there hasn't been any kind of dramatic impact despite the two proclamations issued by the president. I suppose, what employers can expect, though, as you, kind of plan for the rest of the calendar year and into 2021, though, is that, obviously it's been in the news that, USCIS is underfunded. As most know, USCIS, unlike other government agencies, they're funded by application fees. By stakeholders who file immigration benefit petitions on behalf of the foreign national population whom they seek to employ. So because of current agenda items at the federal government level, there has been a noticeable dip in the number of immigration petition filings that USCIS has received, and therefore a lack of funds. So it's not it's not unknown knowledge that USCIS has requested Congress for a bailout, I believe, in excess of $1 billion, so they can continue to employ their adjudicating officers. And unless something was announced earlier today, my knowledge is that there has been really no substantive update regarding that. And if there is no bailout that is issued by Congress in kind of funding USCIS so they can continue to employ their employees, then a massive number of furloughs are going to happen. And if anything, if that's the result, then I suppose it's realistic to think that processing times will be affected. Needless to say, if an agency employs tens of thousands of individuals and a good number of them, whether it be 25, 50, or even 75% are furloughed, then they're going to be operating at less than ideal capacity. So at that point, it might be realistic to think that processing times might be affected, but I suppose it's still early for us to meet that conclusion.
Right. And I think we have a couple of miscellaneous questions along the same lines asking, are H-1B transfers, change of employer petitions in the US affected? And, there's really, we don't see any change to that process at the moment. There's no slowdown in adjudication as of now. I guess we'll have to wait out for the next quarter and see how things look like. Okay. I think we covered most of the questions that are within the scope of this webinar. We did receive a few miscellaneous questions which are not really related. So I think we'll take them up later or offline. And I think with that we can conclude. Let's promise the attendees we'll have another session once we have. I'm sure there'll be new information, new regulations coming out soon. So once we have that, we will schedule our next webinar. And in the meantime, thanks everyone for joining, and we wish you all a good rest of the day. Thank you.